his account or as a member of a Hindu undivided family, has any share or interest in a contract, not being a contract between a cooperative society and government, for the supply of goods to or for the execution of any contract or for the performance of any service undertaken by government. Provided that the disqualification under this paragraph shall not apply to a person, 1, where the share or interest in the contract devolves on him by inheritance.
जरा बात ना करें माइक के सामने लाहौर से, आपकी आवाज यहाँ आ रही है, शुक्रिया जी।
Provided that the disqualification under this paragraph shall not apply to a person, 1, where the share or interest in the contract devolves on him by inheritance or succession or as a legatee, executor or administrator until the expiration of 6 months after it has so devolved on him. 2, where the contract has been entered into by or on behalf of a public company as defined in the Companies Ordinance 1984, of which he is a shareholder but is not a director holding an office of profit under the company. Or 3, where he is a member of a Hindu undivided family and the contract has been entered into by any other member of that family in the course of carrying on a separate business in which he has no share or interest. Or explanation. In this article, goods isko skip karke
not disqualification.
G.
So we can come to
M. G. He holds any office of profit in the service of Pakistan other than the following offices, namely, again, an office which is not whole-time office remunerated either by salary or by fee. 2, the office of Lambardar, whether called by this or any other title. 3, the Qawmi Razakars. 4, any office the holder whereof by virtue of such office is liable to be called up for military training or military service under any law providing for the constitution or raising of a force. Or N, he has obtained a loan for an amount of 2 million rupees or more from any bank, financial institution, cooperative society or cooperative body in his own name or in the name of his spouse or any of his dependents, which remains unpaid for more than 1 year from the due date or has got such loan written off. Or O, he or his spouse or any of his dependents has defaulted in payment of government dues and utility expenses, including telephone, electricity, gas and water charges in excess of 10,000 rupees for over 6 months at the time of filing his nomination papers. Or P, he is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament or of a provincial assembly under any law for the time being in force. Explanation. For the purposes of this paragraph, law shall not include an ordinance promulgated under Article 89 or Article 128. 2. Then if any question arises whether a member of Majlis-e-Shura Parliament has become disqualified from being a member, the Speaker or as the case may be, the Chairman shall, unless he decides that no such question has arisen, refer the question to the Election Commission within 30 days. And if he fails to do so within the aforesaid period, it shall be deemed to have been referred to the Election Commission. 3. The Election Commission shall decide the question within 90 days from its receipt or deemed to have been received, and if it is of the opinion that the member has become disqualified, he shall cease to be a member and his seat shall become vacant. And then 63 is disqualification on grounds of defection. How do you
distinguish between 62 and 63?
My Lord, now, of course, 62 is qualification and 63 is disqualification, but both these conditions are applicable at the time of entry, at the entry point, which is to say that when a candidate files his nomination papers for Parliament or Provincial Assembly, must be eligible under both 62 and not ineligible under 63. Mm-hmm. And subsequently, if once a member gets elected, then again, he must...
No, it doesn't say elected. It says a person shall be disqualified from being elected.
From being elected.
So yes, it's pre-election.
G 62, to, as I said,
63.
G 63 also, it says from being elected.
No,
but
some Article 3 says if he is a member.
If he is a member, then, and if there is anything, for example, now there could be few instances.
If you just, let's go to 62. certain things are factual.
That's right, sir.
He is a citizen of Pakistan. Either he is or he is not.
And the
Two
age,
is age of 25 years. I mean, that's also fact. Either
Right.
you are or you're not. There's no debate here.
and then being on the electoral rolls of a province, that is also
Factual.
Factual.
Now we go to C.
That's again with relation
Factual.
to sector.
Now comes the more difficult ones,
D to G.
which are, I imagine, not easy to ascertain. He's of good character.
And which
Are you of good character, Attorney General? Don't answer that.
no, depends how you see me.
know.
That's what I had to say.
Please don't answer that. Okay. Not suggesting anything.
No, but what?
But I'm just saying.
this actually says it
I'm
all.
just saying your supporters may say excellent character, and
Yes.
your detractors may say
It is
horrible
very
character.
subjective how you see, how you perceive what is a good character. What is good character? So it is.
And
Who will determine it? Who will determine it?
Yes. So that these are also all open-ended.
you know, if you see D, and it goes on to say who is not commonly known as one who violates Islamic injunctions.
Yeah.
So here it is, you may be in absolute violation of Islamic injunctions,
But not commonly
if it is not known.
Yes.
So, okay, so it's a very strange sort of wording.
That's right.
Then we go to E. He has adequate knowledge of Islamic teachings.
Yeah.
I don't know how many will pass muster in this courtroom. What level of Islamic teachings we are talking about.
Right.
And practices obligatory duties prescribed by Islam, as well as abstains from major sins. Okay, now we all pray for forgiveness of our sins. So we are all sinners in that way. He is sagacious, righteous, non-profligate, honest, and ameen. There being no declaration to the contrary by a court of law. Now this is tied up with the court of law clause. The court of law, for instance, the cases before us were people not possessing a degree or producing a fake degree or not a recognized degree. So there is some sort of declaration that this was a stipulation. Now there is another thing inbuilt with that. The Constitution never provided for a degree.
Yeah.
That's subordinate legislation. The Constitution did not want you to be a graduate. I think that was inserted in 2008
Yeah.
by Musharraf was then the president.
2002.
2002.
2002.
So, but it is not one of the prescribed conditionalities either of 62 or 63.
It was perhaps introduced under Clause P, subclause P of subclause 1 of 63. 63(1)P, which permits prescribing additional disqualifications through an
Can
act
we
of parliament.
read it again? P1P क्या है?
He is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament, or of a provincial assembly under any law for the time being in force.
Now, here the word time being has been used twice.
Yeah.
It could have said he is disqualified for being elected. So time being.
Yes.
And it's been used, the word time being has been used twice in this thing. So it assumes it's not a permanent disqualification. I don't know.
That's what the first usage of for the time being actually indicates. What my lord has just observed, that perhaps it is a time-bound disqualification which can be introduced through a statute.
Okay. Now, with regard to the disqualification of, did the law for degrees, the law did not provide a time period disqualification. So the Supreme Court, in the case of Samiullah Baloch, held that since no disqualification period has been prescribed, it will be forever.
So,
For a permanent
so long as the declaration is in the field, the disqualification stays.
And
That's
the
what-
two be resolved now. If the judgment of the Supreme Court also stands and the law also stands, that till the law came into effect, that may have been the position. But since the law has now occupied the field of legislation and prescribed a particular period of time, unless we hear a challenge to the law, which there is no challenge to the law, then why should we disregard the law? That's one way of looking at it. and we don't need to touch the judgment at all, because at that time this aspect of the matter had not been legislated upon either in the constitution or by law. So then the courts kind of filled in the vacuum and said that it should be lifetime because there is no period of disqualification. So Samula Baloch judgment stays intact, but the law has come in place and it is in the nature of a non-obstante clause. That's one reading of it. What do you have to say to that?
So the question would be, can the sub-constitutional legislation control the constitution?
So that is one, and then the second would be, can there be legislative overruling of a judgment without first removing the basis on which the judgment came out? So,
Can we go to the judgment now of the Supreme Court?
my lord,
Relevant provisions, whatever you think are relevant for our reading.
paragraphs, my lord. Ji.
पैराग्राफ 35 है
G35 and
444 पेज पे
Ji. So this is PLD 2018 Supreme Court 405.
ये चार जजमेंट जो
One thing is very important.
उनका रेफरेंस है पहले इसके अंदर ना, चार जजमेंट हैं, उसके साथ फिर समीउल्लाह है,
जी
एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलादीनो भाइयो है. ये चार
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
So, Mr. Attorney General, to nullify Samula Baloch, the amendment would have been in the constitution.
My lord, that's why
I mean, if you're looking at the basis of the judgment,
Yeah.
the basis of the judgment emanates from the constitution. So unless the constitution were to be amended, Samula Baloch could not be undone.
So, because Samula Baloch is interpreting a constitutional provision, and Samula Baloch basically holds that the declaration which is referred to in 62(1)(f) has to remain in field till such time, the declaration in the field, the disqualification stands. Then what my lord has observed carries.
There is no time limit provided under Article 62.
So there are no time limits as far as my lord the Chief Justice had just gone through, took us through clauses A through G. Now, as far as D, E, F are concerned, they are all without any timeline. Now, the question before your lordship, and it was also argued in Samula Baloch. In fact, all the counsels before Samula Baloch.
If we consider that through Samula Baloch the constitution has been amended, then the constitutional amendment is required, as per my understanding.
My lord,
It is interpretation.
my lord, with respect, Samula Baloch also read something into the constitution which was not provided, and
Like, what did they read into the?
my lord, while comparing now, while examining 62(1)(f), the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h), which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that because there is a personal price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases the declarations are there. Now in 63(1)(h), there is a conviction which stands. It's only that
It's really a question of interpretation, because what's very interesting, speaking for myself, if you look at 63 G, H and I,
Yes.
I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests the election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry a criminal punishment,
absolutely.
that carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and test election. But if you just forget to write something in the form, you would be out forever.
And
so how does one reconcile? It's a matter of interpretation.
yes, so that is what my respectful submission would be, because in both, in G, H, and also in I, there is an adverse finding against the person, a declaration by a court of law against that person. In those proceedings, those declarations, of course, subsist. He serves the time or whatever punishment provided by law, and then he can come back in after 5 years. Now here, while looking at 62(1)(f), where there is this, the standard of proof is lower compared to those criminal proceedings under 63(1)(h), which is beyond any shadow of doubt, and that declaration has still come out beyond any shadow of doubt. And here is preponderance of evidence or somewhere between the two, and here the person is out forever.
But before we go into that, could you just explain to us how can any court, a civil court, grant declaration which is in the negative? I mean, how can a court grant a declaration that you're not sagacious? That cannot happen. So how does that work? I mean, I've been always perplexed about this. We can't get a negative declaration from any court. Can a court say that you're not sagacious? Why would that happen? Because no civil proceedings could lead to a negative declaration. It's always positive. So I don't understand how a court will ever give such a declaration. So then most of the courts which have given this declaration are the constitutional courts. So you have
That's another
degree
question
case.
now.
And in those cases, is the declaration absolutely clear? I mean, does it say that you're not sagacious, or then we infer from the judgment that because you presented a fake degree, as a consequence, we understand that you are not a mean? I mean, let me just go to the language of 62(1)(f) to understand what do we mean by declaration.
Declaration, and also what is a court of law, because, and I say this, and my lord has just observed, in Ishaq Akwani's case in 2015, a 7-member bench actually framed these 4 questions. They left them unanswered for some other case in future, and those questions were that what would be that court which is to give this sort of declaration? What would be the
happened
procedure?
then in that case?
They left it open, sir. These questions were not answered by a 7-member bench. So which court would it be? What procedure would it follow? What would be the standard of proof? And who will have the locus standi? Now these are the questions which are very, very relevant for the purposes of for this declaration by a court of law. And then also whether the courts exercising, let's say, constitutional jurisdiction, who cannot record evidence, where witnesses cannot be cross-examined, a person against whom an allegation has been brought cannot really defend himself as he is able to in a trial. Would the declaration coming from constitutional court suffice for 62(1)?
Mr. Attorney General, the question which has been there for a while now is, first of all, can there be a civil court granting a negative declaration, number one? And number two, the question is that in constitutional proceedings where there is no evidence being taken, the court has arrived at a decision that a fake degree has been, for example, I don't know what the other cases are, fake degree has been presented by this person, does not necessarily mean that the court is moving further and saying that you are now non-sagacious or whatever. It's simply saying in this particular matter a false degree was presented. But I don't know of any judgment where they've actually gone ahead and said then as a consequence you're a fraud. So I don't know. So is there a declaration actually coming out of the constitutional court also? And can they, without taking any evidence, give such a declaration about a person?
My respectful submission is, my lord, that a constitutional court, now mindful that this 7-member bench left these questions open, but then there are 2 judgments. One in PLD 2015 Supreme Court 265, which is Panama 1. Justice Ijaz Afzal Khan, speaking for majority, said that a court of law for the purposes of 62(1)(f) would be a court which can actually record evidence, which is a plenary court of original, revisional, appellate jurisdiction in civil and criminal proceedings. But
without recording evidence, declaration can be given?
Cannot be given. Yeah. And then the same...
But even a negative declaration cannot be given, even if you record evidence. Right, I don't understand this.
And then in Aladino Bhayo, the second Aladino Bhayo, the review Aladino Bhayo, they revisited the original judgment which was given in 2013, where under it was held that once a declaration under 62(1)(f) is given, it does not go away with the flux of time.
Declaration में तो यही है ना कि person may not file his own case for declaring him Amin.
Yeah.
Somebody has to challenge his character.
That's right.
Then in that case, the declaration will come whether he is Amin, sagacious, righteous or not.
Yeah.
So ये डिक्लेरेशन होगा ना, खुद तो जाके नहीं मांग सकता
और
डिक्लेरेशन.
दूसरा नेगेटिव एज पर
Somebody will come challenging.
सिर्फ पैटर्निटी पे हो सकता है शायद, एक एक्सेप्शन है 42 में, देयर इज नो अदर एक्सेप्शन.
सेक्शन 42 में तो लीगल कैरेक्टर कोई डिनाई करता है तो सूट फाइल होता है ना. If somebody is denying his legal character, then he can file the suit under section 42 of the Excessive Act.
What right?
और अगर आप कॉन्स्टिट्यूशन कोर्ट्स के केसेस भी ले लें ना, तो फॉर एग्जांपल somebody has not, for example election tribunal says that the nomination form में फलां चीज नहीं है, तो मिस डिक्लेरेशन इन्होंने की है. चलिए ये बात तो हो गई, इन्होंने मिस डिक्लेरेशन की. अब इसका क्या मतलब, फिर हम खुद जोड़ते हैं, हम कहते हैं कि क्योंकि मिस डिक्लेरेशन की है इसलिए फिर आप अमीन नहीं है, इसलिए 62(1)(f लग. बट द कोर्ट हैज नॉट सेड इट. द कोर्ट इज नॉट डिक्लेयरिंग दैट यू आर नॉन सगेशियस और नॉट अमीन, बट द कोर्ट इज सिंपली सेइंग यू हैव फाइल्ड, देयर हैज बीन अ मिस डिक्लेरेशन इन द फॉर्म. सो उस पर जरा एलैबोरेट करें, हाउ डू वी एक्चुअली गेट, वेयर इज द डिक्लेरेशन, एक्चुअल डिक्लेरेशन फ्रॉम द कोर्ट.
उसमें कहीं पर वो करेक्शन के भी प्रोविजन है अब जो नॉमिनेशन पेपर्स हैं.
और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now, this is again very interesting because in some judgments in Sher Alam's case, for example, the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo moto notice under 184(3) and gives
quo warranto देखे ना, वो तो आर्टिकल 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
वो तो ऑफिस में जाने के बाद है, not prior to.
जी, ऑफिस में जाने के बाद होगा. But as far as that declaration is concerned, question is, can that declaration be given in those proceedings, or for that person somebody has to go to civil court or some court which has the original jurisdiction to try and receive evidence, allow the person against whom an allegation has been brought to cross-examine.
एक चीज जरा देखिए, come back to Article 62.
My lord.
Read G.
He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan.
Yes. Now, if we read 62(1)(g) on its own with the judgment of Samiullah case, the ban is lifetime ban.
But
If we read them together.
जी हाँ, मतलब उसका भी
Now read
मतलब यही होगा.
63(1)(g).
जी.
It's the same language, ideology of Pakistan.
जी, for
And
propagating.
here it prescribes a ban for 5 years.
जी, or the sovereignty, integrity, or security of Pakistan.
So it's the same 62(1)(g) and 63(1)(g)
That's
are
right.
more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Sabiullah Baloch to 62(1)(g), it is lifetime ban. And if we apply 63(1)(g), it is 5-year ban. Unless you say 62(1)(g), Sabiullah Baloch is not attracted to 62(1)(g). That could be one argument. So
it's interesting what my lord has observed, because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए, तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक डिक्लेरेशन आ जाए, तो then he's gone.
if he has been convicted and goes to jail, so his sins are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years, and if your guilt has not been established, because every criminal case has 2 components, conviction and sentence.
That's right.
You can be convicted and you can be sent on parole, or you can be convicted till the rising of the court, or whatever it is, or maybe not. Say for good conduct, we don't convict you this time, we don't sentence you this time, we just convict you.
That's right.
So that will be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yeah,
I would rather
the
go
rising of the court, so I can just go back after 5 years.
So then see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague. And they're overlapping as well because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens?
Hafiz, alim.
So एक तो वो समझ नहीं आ रही, लेकिन फर्क सिर्फ ये है कि F में तो ये है कि एक डेक्लेरेशन खड़ी हुई है थर्ड पार्टी की, तो जब तक वो खड़ी हुई है वो चलता रहेगा. That's what Samiullah Baloch saying. Samiullah Baloch actually turns on the declaration.
वो हुआ ये कि actually 18th Amendment में ये जो declaration by court of law लाने का purpose तो ये था कि वो returning officers जो है ना वो डिटरमिन ना करते रहे या इस किस्म का एलिगेशन कोई और रैंडमली ना आकर लगा दे, और ताकि ये जो डी, ई और जी के अंदर जो हो सकता है वो एफ में ना हो.
आपके मुताबिक
उल्टा हो गया.
How does D, E and G play out actually? I want to ask this question. आज से 10 साल पहले किसी ने इंटेग्रिटी ऑफ पाकिस्तान के बारे में कोई बात स्पीच कर दी, बस खत्म हो गई बात. अब वो इलेक्शन नहीं लड़ सकता.
ये देखिए कुछ लोग होते हैं तो उन्होंने 5 years कर दिए, वो कहते हैं यस आई सीन द लाइट. अब इस्लाम में भी तौबा की गुंजाइश आखिर मिनट तक है. वो कह सकता है जी मुझे, जैसे माय लॉर्ड ने ऑब्जर्व किया कि मुझे इस्लाम के बारे में नहीं पता था, अब मैंने सारे अब लाइफ टाइम बैन उसको कर दिया कि वो फिर शायद हाफिज बन गया हो सकता है, आलिम बन गया हो सकता है, आप और बेहतर और हम सबसे बेहतर कुरान शरीफ समझने लगा हो, और वो लाइफ टाइम बैन में आ गया क्योंकि उसको 20 साल पहले या 10 साल पहले या 5 साल पहले इन चीजों के मुतालिक इल्म नहीं था.
समीउल्लाह बलूच जो है इट एक्ट्स एज अ गलिटीन. वो कहते हैं कि जब आखिरी अपील में जब आप आएंगे तो बस उसके डिसीजन से पहले तो अगर आप रिपेंटेंस कर लें तो हो सकता है, वरना वंस that happens then there is no repentance.
कहाँ छोड़ा?
नहीं छोड़ा. 184(3) में तो वैसे ही नहीं होता, बट अदरवाइज भी नहीं.
रिपेंटेंस कहाँ लिखा हुआ है?
साहब सुनने जरा, जी साहब
समीउल्लाह बलूच
देखें, इसमें असल बात यह है कि डिफरेंस हमने मालूम करना होगा 62 63A में. व्हाट इज द डिफरेंस बिटवीन द टू? एज फार एज आई एम कंसर्न, 62 is not giving power to decide against a person. देखिए इसमें तो सिंपल ये इट इज डिपेंडेंट अपॉन 63 में जो कार्रवाई करेंगे वो दिखाएंगे. 62 में वो कहेंगे यू आर नॉट क्वालिफाइड, वेयर एज डिस्क्वालिफिकेशन इज इन 63. अगर कोई शख्स सपोज कोई काम करता है, कोई गलत काम करता है, तो अगर आप जी और एच को पढ़ लें, जी और एच वो डिटरमाइन करते हैं कि कोर्ट ऑफ लॉ से जब उसको कोई डिक्लेरेशन हो, ये उस डिक्लेरेशन की बात हो रही है. आई थिंक सो जी. आइए इस पर बात करें कि ये 62(1)(f) कहाँ पे पावर देते हैं कि आप इतने टाइम के लिए डिस्क्वालीफाई हो, इतने टाइम के लिए. वो तो सिर्फ ये बताते हैं कोई शख्स पेपर सबमिट हो रहे हैं उससे पहले बता दिए कि ये फ्ला कोर्ट से इसको सजा हुई, लिहाजा पेपर खारिज. दैट्स ऑल, मैटर एंड्स. द अथॉरिटी डीलिंग विद दिस मैटर हैव नो पावर टू डिसाइड द डिस्क्वालिफिकेशन पीरियड ऑफ दैट पर्सन. वो डिस्क्वालिफिकेशन के पीरियड तो 63 ने बता दिया. ये सजा जुर्म करोगे तो इतनी सजा होगी, और उस जुर्म की सजा पूरी होने के 2 साल बाद जब आप निकलेंगे तो फिर आप क्वालिफाई होंगे. तो ये आप जो पहला सवाल जो आपसे किया कि डिफरेंस, आप डिफरेंस जब बताएंगे तो खुद बखुद पता चलेगा व्हाट इज 62 एंड व्हाट इज 63.
So if 62(1)(f) is juxtaposed with 63(1)(h), H and H both.
H moral turpitude.
H moral turpitude है because वो उसके साथ dishonesty etc. वो उसके साथ है moral turpitude being very broad, और वो examine हुआ Samiullah belief. उसको अगर आप सामने रखें तो the consequence then, if they are to be reconciled, then the consequence is only one, which is that the timeline which is provided for the declaration in 63(1)H must necessarily apply to the time to the
फर्क ये हो
declaration
गया ना
in 62(1)F.
कि एज में अगर conviction हो गई because it attracted an offense and so it led to conviction, then he can come back. But if it was lesser than even a case where it could constitute an offense and so he could not be taken in a criminal case, a simple declaration was given on the civil side, that goes on unlimited. अब यही समझ नहीं आती because otherwise then we also have to stay away from the concept of reading into the constitution.
But now that you have started reading in
So
63A, so I was just
that is also a question.
So you must stop from reading furthermore.
Reading in
Yeah, just another aspect, if you can attend to. Can you read D
my lord.
again?
He is of good character and is not commonly known as one who violates Islamic injunctions.
Now please read F.
He is sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law.
Now, what does this mean? There being no declaration to the contrary by a court of law. In clause D and in clause E and in clause G, these words are not mentioned.
That's right.
So either you say clause D, E and G are redundant, they're meaningless clauses, because the words there being no declaration, either the same wording should have been followed. And I can't, at least I cannot understand the difference between good character and sagacious. I mean, good character is something different from sagacious. Is good character different from being righteous?
Righteous,
non-profligate. What does that even mean? What does non-profligate mean? What does it mean?
Who doesn't spend wastefully?
Israf.
Yeah.
So good character.
Yeah.
So if you are doing wuzu and wasting water, you become a profligate. Because there's a hadith of the Prophet.
That's right.
Do not waste water. And even if you're standing next to a flowing river. So then he's a profligate. So, and then we go honest. Good character. Every good character person is an honest person, I would imagine. And ameen. I mean, you know, these are words which a Muslim would never even dare utter in deference to the Holy Prophet, that only he is and none of us are. I mean, that is humility and abject humility. You will never say that. Otherwise, why would you seek forgiveness for whenever someone dies? Please forgive his sins. Do we ever say he's entitled to Jannat and Allah Ta'ala grant him Jannat? He never committed a sin. We don't even pray that for ourselves. No honest person will say any of these things, that he's sagacious, righteous, non-profligate. Even the greatest saints in Islam were scared when they were dying, that they were scared of death because they were apprehensive of what may they be meeting in the hereafter. So I don't know, is this generally a wish list kind of situation as opposed to because otherwise everybody can, if I was filing a lamination paper and if someone says he's not of good character, I would not even challenge it. I said, I'm sure I've done something wrong in my life. Maybe I've done it wrong yesterday, so I don't know. So if you're honest and you say, right, this person is right, I am not sagacious, righteous, non-profligate, honest. I do not switch off the lights when I go out of a room. I waste electricity. I waste human resources which the Almighty provides. So where does it end then? I can bring any case into disqualify someone, and I want to save someone, I can also do the same thing.
That's why.
Should such power vest in judges
And
who are themselves humans?
That's why
They
critical.
want a greater test for parliamentarians than they have for themselves. Does this language find mention in the oath of office of a judge? That I'm not profligate? Does it mention in the recommendations of a judge? All it says you have to be 45 years of age, practicing law for 10 years.
It could be
So we have a lower standard than parliamentarians. Why is this language then not reflected there as well? You know, let's accuse ourselves before we accuse anybody else what they are or what they are not. So either we have a much lesser test, we can't, at least I would be very scared to meet this test, terrified to meet this test. So either we don't have a similar test, so we have to read the constitution as a living whole, and where the constitution has brought down the acts, it clearly says 2 years, 5 years, 3 years, 2 years, or it's factual, you're not a citizen, fine, that's very clear. There is no punishment here, but you're out. So without a punishment, you're out. There's no punishment. So, but suppose a person is a citizen of Pakistan, not a Pakistani citizen, but becomes a citizen of Pakistan later. Would he stand disqualified for life? Suppose he filed a nomination paper and he had another nationality or whatever, and he got disqualified. Is it disqualification for life? And then subsequently he said, okay, I've surrendered my US nationality and now I want to contest. So I don't know, we have to read it in a way that is meaningful. And we must bear in mind the conditionalities that were imposed to exclude people from this, the degree situation. Thankfully, it wasn't there when the Qaid was around, because he would have been disqualified.
That's right.
He wasn't a graduate.
amendment कब हुई? ये amendment
2002 की 8 की
2002 में.
तो किसने की amendment?
My lord, this was presidential order.
क्या वो president खुद इन पे उतर सकता था, इन तमाम requirement पूरी कर सकता?
But ये general military general ज़ियाउल हक
नहीं होते, बाद में डिग्रीज करते हैं. शुरू में नहीं होता.
Non-elected members अगर amendment करेंगे तो यही होगा.
Mr. Attorney General, the question is that while we're looking at D, E and G, which to my mind appears to be a guideline for the voters, the actual gatekeepers, and they might keep this in mind when they're voting, because nobody can execute them and put anybody behind anything. So D, G, E and G to sir guideline ho sakti hai voters ke liye, and that's never been agitated. The $1 million question is, how do we look at the line, no declaration to the contrary by a court of law? What do we do with this? This is in the Constitution.
If I may,
I think my lords have raised the questions. Can we read the law on declarations? What is the law on declarations? Section 42 of the
Section 42 of the Special Relief Act.
I would imagine, is that the only declaration that has been indicated here?
There's no other declaration. और तो कोई है ही नहीं.
कोई और law होता है declarations का? Specific Relief Act.
Only Special Relief Act, Section 42. Legal character के ऊपर जो है ना, वो that is the only law.
Declaratory suits are filed under 62(1)(f).
Section 42.
Constitution में रहा. ये तो
इन्होंने कर दिया ना, बट अगर कोई चैलेंज करेगा तो वो तो 42 में ही करेगा ना. नेगेटिव डिक्लेरेशन.
Negative declaration concept है ना. Positive declaration is not negative declaration. We have held in paternity cases that you cannot do negative declarations.
paternity can
किया ना, negative positive.
negative कर सकते हैं paternity.
Negative positive, हाँ. नेगेटिव नहीं हो सकता है क्या?
person regularly character right of any property.
दे देना इनको स्पेसिफिक रिलीफ एक्ट सर. आप अटर्नी जनरल को दे देना.
कह सकता हूँ कि हम honest.
यही दे देना प्लीज.
ये मैं दावा फाइल कर सकता हूँ कि मैं honest.
Yes, Ji.
So that's it.
Ji, sir. I have it before me. Mr. Jilani's iPad is very helpful. Discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Bar to such declaration, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so.
By the court, to what is understood by court? A civil court?
Yes.
Under Section 9, or is it a constitutional court?
Now, this is it's a civil court where evidence can be led. Witnesses can be examined, where a burden of proof is discharged, and then there is an opportunity of rebuttal.
Suppose in a case where I've done so even, we observe hearing a civil petition for leave to appeal or an appeal that the appellant had dishonestly filed a suit. Suppose we hold that, and we've held so, and impose costs on him. Will that constitute a declaration of a court of law in terms of Article 62(1)(f),
My respectful submission is no, sir.
Why?
Because you are not a court where that particular issue is actually conclusively determined through a trial.
So we could observe in other cases. We could say in a criminal case that I don't believe this witness is a liar. And that witness will then be struck by 62(1)(f) because it's a declaration of a court of law. In a judgment in a criminal case, he was not an accused there, but he was a witness. And the court says, I don't trust this witness. I found him to lie.
My lord,
so it's, then you can bring out every case. We may make an observation against a lawyer. He misled the court, for instance. Sometimes we do that.
My lord,
regretfully. And then if a lawyer contests election,